You may be wondering, what's the difference between a trust and a will? Maybe you have a will, but you're wondering, do you need a trust instead? Maybe you don't have either of them, and you're wondering, which one should you get? In today's video, we're going to be talking about the difference between a trust and a will, and what might be right for your family. Hello, and welcome to my channel. My name is Ellen Cookman, and I'm an estate planning attorney who specializes in special needs planning. On this channel, we're going to talk about how to set up a special needs trust to protect your loved one who has special needs. We'll talk about the importance of setting up a trust, what's the difference between a regular trust and a special needs trust, regular estate planning, a revocable living trust, how to avoid probate, trust administration, and many other relevant topics. If this information sounds useful to you, please consider subscribing and hitting the notification bell so that you'll be notified when new videos come out every week. I'm a certified specialist in estate planning, and my law firm has helped hundreds of families navigate the complicated process of setting up their estate plan with special needs components. I'm excited to share all of the knowledge that we've learned over the years with you. Okay, so let's get into this. What's the difference between a trust and a will? First, I want to let you know that I'm talking about California law here. There are some states where everything is done differently. Every state has their own estate planning rules. So here we're talking about in California. So what we used to find is everybody did wills, all right? And that's what you see in some movies like Gran Torino or Knives Out. They have this formal will reading where they say, I hereby bequest my Gran Torino to such and such neighbor, right? We don't have that anymore. So here's the problem. When you have a will, it goes through probate. And the probate process is a court process here in California, which is expensive, it's time consuming, and it's public. And so we don't like that. But I want to kind of tell you the background of how we developed the Revocable Living Trust. So people used to have wills for a while, and then they realized, hold on, what the court is doing is figuring out who's inheriting things and who's managing that process of distributing to the next generation. We call that, in a will, we call that person the executor, the manager. So in the late 70s, early 80s, they developed this thing called a Revocable Living Trust. Now, I like to think of a trust as a contract. It's an agreement between the people setting up the trust, or we call them grantors or settlers or trustors, and the people managing the trust, who are the trustees, for the benefit of the beneficiary. Now, with a revocable living trust, you wear all three hats. You, setting it up, you're the grantors or the settlers, you are the initial trustees, and it's for your benefit. So these trusts were developed to be able to avoid probate. In the revocable trust, you say who gets your stuff. You say, how is it to be held? Does it go directly to them, or is it held in a trust? Right? It could be held in a special needs trust for a disabled child. It could be held in a dynasty trust or a lifetime trust. It could be held until age 30 or 35 and then distributed outright when you think your child might be a little bit more mature. So you spell all of this out in the trust. And you also say who's going to be the successor trustee, who's going to take over managing the trust when you're gone, or if you're incapacitated. So the trust spells that all out. It's like the instruction manual. And the wonderful thing about a revocable trust is that it does not go through probate. It's specifically designed to avoid probate. All those questions that the judge has to figure out during the probate process are answered in the revocable trust. I happen to be an attorney who hates going to court. So I love doing trusts for my clients so they can avoid the probate court process. Now, when you do a trust, you still need a will. So this might be confusing, like, why would you need a will if you need a trust? So the will now has a different function. It now becomes a cleanup document. So when you're creating your trust, you also need to fund the trust. And we will be talking about funding the trust in a separate video that I ask you to watch. But when you create your trust and you fund it, What happens if you forget to put something into the trust and it's still sitting out there in your name? Maybe you inherited it and you just never put it in the trust, or maybe you refinanced your house, you never put it back in. The will is what we call a pour-over will. It's a cleanup document. So the will says, if I forgot to put something in the trust, the will scoops it up and pours it over into the trust. It's my intent that everything goes into my trust. So those two documents act hand in hand. You have your revocable living trust and you have your pour-over will, and you create both. But it's important to know that the linchpin of the drafting is the revocable living trust. That's what holds all of the assets. That's what says where everything goes. So our goal is that the pour-over will is superfluous. It's not used. Now let me mention though, that in the pour-over will, that's often where you can nominate guardians. Okay, so if you have children who are minors and they need to be raised by somebody, if you and your spouse or all the parents are gone, then you say, I'm nominating my sister or this person to act as guardian of my minor children. You put that in the will because that always goes through the court system. Whenever you're dealing with somebody who's a minor or disabled and you're setting up who's going to raise them, who gets to make decisions over them, the court always wants to be involved. You can't avoid that. So that's going to go into the will. If this information is resonating with you, I ask you to click the like button below so YouTube can push this information out to more families who can benefit from it. So why don't we like probate in California? Perhaps you've moved from a different state. And some states, probate is very friendly. Like in Texas, you can be appointed as personal representative of an estate like in a day. Here in California, it can take 3 to 4 months just to get a court hearing date. So probate, our court systems are really backed up. Depending on which county you're in, for example, Alameda County and Santa Clara counties right now are backed up 5 to 6 months just to get a hearing date. So it's really horrible that way. Also, when you're going through probate, the fees for the attorney and for the executor or personal representative are set by statute. So when you add up those fees, it's going to be like 4 or 5% of the total estate. So that's really expensive. And then the other challenge is that anybody can access these records. So what I've found is once we file for probate, we start getting a lot of solicitations from realtors, from other professionals who want to help, but you might already feel bombarded by emotions, by other things, and you don't want to deal with that. Also, this lets somebody know, perhaps some burglars, that maybe they'll try to break into the house that's recently been vacated by the deceased person. So we try to keep things as private as possible. Just to let you know, a revocable living trust is completely private. It's not recorded anywhere. Usually as attorneys, we keep copies, and you would keep the original as the client, but it's not filed anywhere, so nobody can access that. So it's great from a privacy perspective. So let's talk about whether you really need a will or a trust. Okay, so in California, as of this time of recording in 2022, there's a magic number, and that number is $166,250. It used to be a nice round number, $150,000, and then it went up a little bit and caused all of us great anguish having to say this big number. But what that number represents is the amount of stuff that you can have in your name without beneficiaries named and still avoid the probate process. All right, so let's say you have a $50,000 bank account and that's all you own. Well, you could name a beneficiary for that account, or you can say in your will, it goes to so-and-so, and it still avoids probate because it's under $166,250. But now let's say you own a house, and in California, all houses are more than that, much more than $166,250. So in that case, you would need a revocable living trust to hold the house and to avoid probate. So just about all of my clients, just about everybody that I talk to here in California even, needs a revocable living trust. Just about everybody does. And then you also do a pour-over will. Now keep in mind that does not control where retirement accounts go. So you might have sizable retirement accounts. You don't need a trust for that. You can just name people who you want to receive those. However, if you want them to receive them held in a trust, you still need to do the revocable living trust and more protective provisions. So we've really just scratched the surface on estate planning in this video. If you'd like more information on estate planning, I ask you to click on the link below where you can access a full-length webinar that I've given on estate planning, and that'll give you a lot more information that should be very useful.